So very good evening all the participants. So as we have already discussed, we are discussing the three processes of insolvency resolution process which are available for corporate persons. So these three processes are CIRP, fast track process, and then pre-pack. Pre-pack is available on a lower threshold of default of 10 lakhs, whereas normal CIRP and fast track, for that minimum default is 1 crore rupees. The first thing the insolvency professional has to make is the public announcement. So that public announcement has to be made immediately, and immediately here means within 3 days of the appointment, and he will call for submission of claims, which shall be normally 14 days. And then there are other timelines also, like 90 days from the insolvency commencement date till the time the issue of request for resolution plans is given, and thereafter also, even before 7 days prior to the meeting on the resolution plan, claims can be admitted, but that is subject to ratification by COC and adjudicating authority, and our RP will submit an application for condonation of delay also in those cases. So those are the recent amendments in the claim submission. And as we know that he has to manage the affairs of the CD, and this IRP or RP will exercise the powers of the board of directors of the CD. He is responsible for all the compliances under any law on behalf of the CD during CIRP, whether it be filing of income tax returns, GST returns, TDS returns, any renewal of licenses, renewal of insurance. So whatever are the compliance requirements, the IRP or RP is responsible during the CIRP period. He will collect all information relating to the assets, liabilities, finances, and operations of the CD. He will receive, collate, and verify claims, including he will make best estimate of the claims where it is not precise, because some of the claims may not be crystallized. So in those cases, what he will do is he will make a precise estimate of those claims. Just right. He will ascertain the class or classes of creditors, identifying and selecting AR, applying to A for appointment of AR. Form AB is there within 2 days of the verification of claims, and he will provide the list of such creditors to authorized representative, and he will provide electronic means of communication between the AR and such creditors. Because in case of class of creditors, regarding class of creditors, we have already discussed that there could be a class of creditors with minimum 10 financial creditors, and there could be a class only in respect of financial creditors. There cannot be a class in respect of operational creditors. Now, who will ascertain whether there is any class of creditors? So this has to be ascertained by the IRP after having a look at the books of account. So he will ascertain whether there exists any class of creditors. Examples of class of creditors could be the deposit holders, debenture holders, which are governed by the same terms and conditions of payment and repayment. Merchant bankers, underwriters, there could be so many, home buyers. So what he will do? He will make a list of the creditors belonging to a particular class, and he will identify 3 insolvency professionals based on the highest number of creditors who are having addresses. Suppose creditors are spread all over India. So he will see where the highest number of creditors are residing. So we will select one AR from that who has to be an insolvency professional, then second, and then third. These 3 choices will be given to the persons who are filing their claims as a class of creditors, and they will indicate their choice, and the AR with the highest number of votes will be selected, and his appointment will be done ultimately by the adjudicating authority. The constitution of committee of creditors has to be done by the IRP, and he will file a report with the adjudicating authority. He has to hold the first meeting of the COC within 7 days of filing of the report, and RP, who is an AR, shall circulate agenda to class of creditors and announce voting window at least 12 hours before it opens and keep it open for at least 12 hours. Actually, now in the meeting, two types of creditors will be coming. Individual financial creditors and then creditors belonging to a class. But all the creditors which belong to a class will not be invited to the meeting. On their behalf, AR will be attending the meeting. Now the IRP or RP will provide the means of communication between AR and such creditors to the AR. And then AR will in turn get in touch with those class of creditors for ascertaining their vote. And he will be carrying out the instructions of the class of creditors. The IRP shall be carrying on the functions of RP from 40th day till the RP is appointed. If any information has to be filed, it has to be filed by the IRP or RP. He will monitor the assets of the CD, manage its operations, take control and custody of its assets. Now regarding custody and control, there is a change in the regulations. So let me take you to that changes in the regulations. So I have shared one PPT on the amendment in CIRP regulations. I hope now it is visible. So the change, what is the change? Let us see some of the changes in the regulations. There is a regulation, there is a change in regulation number 3A of CIRP regulations, which talks of the assistance and cooperation by the personnel of the CD. So it says the IRP or RP, as the case may be, shall take custody and control as specified under this regulation from the personnel of the corporate debtor, its promoters, or any other person associated with the management of the corporate debtor, as the case may be, of the following: the record of information relating to the assets, finances and operations of the corporate debtor referred to in clause A of section 18 and such other information required under regulation 36. Why this change? Why this change came? This change came because there were a lot of issues in custody and control. So they have inserted in the regulations as to what is the responsibility of the management and what is the responsibility of the RP. Because for these things, adjudicating authority was being approached. So now clear-cut responsibilities have been spelled out both for the IRP or RP and the CD. Second is the personnel of the corporate debtor, its promoters or any other person associated with the management of the corporate debtor shall provide to the IRP or RP, as the case may be, a list of assets and records while handing over their custody and control. And the IRP or RP may, after taking such custody and control, if deemed necessary, identify persons in whose possession these assets and records will be held. Right? Where any asset or record has not been handed over or the list has not been provided under sub-regulation 2, the IRP or RP, as the case may be, shall himself prepare a list, because sometimes management is not available at the site. Maybe they have fled the country. So now in such situation, what will happen? This is given in sub-regulation 2 of regulation 3. So what it says? Regulation 3A. Regulation 3A2. So what it says? Where any asset or record has not been handed over or the list has not been provided under sub-regulation 2, the IRP or RP, as the case may be, shall himself prepare a list of assets and records while taking custody and control, and the IRP or RP may, after taking such custody and control, if deemed necessary, identify persons in whose possession these assets and records will be held. So there are two situations. One, when management is available. So management will prepare the list and they will hand over the custody and control. Second, where management is not available or no asset or record has been handed over, then IRP or RP shall himself prepare a list. Each list of assets and records shall be signed by the parties present and by at least two individuals who have witnessed the act of taking control and custody of such assets and records. The IRP or RP, as the case may be, shall requisition from the personnel of the corporate debtor. So here the duty has been cast upon the IRP or RP. So the IRP or RP, as the case may be, shall requisition from the personnel of the corporate debtor, its promoters, or any other person associated with the management of the corporate debtor, as the case may be, the information relating to the assets, finances, and operations of the corporate debtor referred to in clause A of section 18, and such information required under regulation 36, which were required to be maintained by the corporate debtor but have not yet been handed over. The IRP or RP, as the case may be, shall requisition from the personnel of the corporate debtor. So the duty of requisitioning has been cast upon the IRP or RP. Its promoters or any other person associated with the management, as the case may be, the assets which are recorded in the balance sheet or in any other records referred to in clause F of section 18 and whose custody has not been handed over. Suppose there is an inventory as per books, but the inventory is not there physically present, then he shall requisition from the personnel of the CD as to where is this inventory. Because all these issues will crop up when the IRP or RP will make an application under 19.2 seeking cooperation, seeking assistance of the adjudicating authority. So an application made under subsection 2 of section 19 in respect of failure to provide any asset or record as requisitioned under the code and this regulation shall show presence of such asset or record in the notice of requisition and absence of such asset or record in the list of assets and records taken in control and custody under sub-regulation 2 and 3. Now what is the meaning? The meaning is when the IRP or RP is making an application under section 19.2 seeking assistance of the adjudicating authority, then he has to provide them two things. Number one, that they have requisitioned the records and the records have, the asset or record have not been provided. This is the meaning. Then there is another change regarding access to books. Operating separate bank account for each real estate project. So it says where the corporate debtor has any real estate project, the IRP or RP, as the case may be, shall operate a separate bank account for each real estate project. Handing over the possession. Because this was also an issue, sometimes in case of real estate projects, what happens is that the home buyer has paid all the money, whatever was due from him, but still he has not been handed over the possession. And it is appearing in the books of the CD as unsold inventory. So in such cases, the issue comes whether this possession can be handed over. So these were the issues which were being taken to the adjudicating authority. Now they have made the change in the regulations itself. They say if the home buyer has made the complete payment and nothing is to be done from his side, then let the RP facilitate possession. So it says after obtaining the approval of the committee with not less than 66% of total votes, the RP shall hand over the possession of the plot, apartment or building or any instruments agreed to be transferred under the real estate project and facilitate registration where the allottee has requested for the same and performed his part under the agreement. So if the home buyer has paid all the money and he requests, so the IRP or RP shall facilitate registration after obtaining the approval of the COC with 66% majority. So these are some of the major amendments which we must look into. Next is submission of proof of claim. So it says a creditor shall submit claim with proof on or before the last date mentioned in the public announcement, that is 14 days from the insolvency commencement date. Provided that a creditor who fails to submit claim with proof within the time stipulated in the public announcement may submit his claim with proof to the IRP or RP, as the case may be, up to the date of issue of request for a resolution plan under regulation 36B or 90 days from the insolvency commencement date, whichever is later. Earlier, what was the timeline? He could file his claim, he could submit his claim with proof up to 90 days. But now there is a change. The period has further been extended. So he can submit his claim with proof up to the date of issue of request for resolution or 90 days from insolvency commencement date, whichever is later. Provided further that the creditor shall provide reasons for delay in submitting the claim beyond the period of 90 days from the insolvency commencement date. And naturally, So he will be included in the committee of creditors from the date of admission of the claim. Where the IRP or RP, as the case may be, does not collect the claim after verification, he shall provide reasons for the same. Another important change which has been made in CIRP is regarding the appointment of facilitators. So this is a new concept, this appointment of facilitators. So what it says, where the number of creditors in a class exceed 1000, because earlier there was only concept of authorized representative, but now there is a one step down also. So there is a concept of facilitator. So it says, but it is applicable only when the number of creditors in a class exceed 1000. The committee may direct the IRP or RP, as the case may be, to appoint an insolvency professional other than the IRP, RP and AR, or any other person as facilitator for a subclass within the creditor, subject to the following conditions. Number one, the appointment of facilitator shall be considered only if, after the first meeting of the committee, a subclass comprising of at least 100 creditors out of the total number of creditors in a class request for the inclusion of an agenda for such appointment along with the name of the proposed facilitator. So first of all, after the first meeting, a request has to be made by a subclass comprising of at least 100 creditors out of the total number of creditors in a class. Okay. And these facilitators can be appointed only when the number of creditors in a class exceed 1000. The total number of facilitators shall not exceed 5. Okay. Now if we compare the IRP or RP with the class teacher, the AR is the monitor and this is sub monitor, facilitator. So total number of facilitators shall not exceed 5 and the fees for facilitator for each subclass shall be 20% of the fees specified for the authorized representative, and such fees shall be part of the insolvency resolution process cost. The committee may replace the facilitator on the recommendation of a majority of the members of the subclass. Okay. Now what shall be the roles and responsibilities of the facilitator? Let us also understand this thing. The roles and responsibilities of the facilitators shall include the following: facilitating communication between the authorized representative and the creditors of the subclass. So the AR and the creditors of the subclass, so he will facilitate communication between these two. Like AR was facilitating the communication between the RP and class of creditors. So similarly here he is facilitating communication between the AR and creditors of the subclass. Attending the meetings of the committee as observers to facilitate communication between creditors of the respective subclass, providing information and clarifications to the creditors in a subclass about the insolvency resolution process as per advice of the AR, and any other tasks assigned by the committee to improve representation and communication. Meetings of the committee. A resolution professional shall convene a meeting of the committee before lapse of 30 days from the last meeting. So earlier this provision was not there. Now basically one meeting in a month. So it says a resolution professional shall convene a meeting of the committee before lapse of 30 days from the last meeting. Voting by the committee. Seek a vote of the members who did not vote at the meeting on the matters listed for voting by electronic voting system. So all these changes are there. Now let us again go back to the chart. So we were studying the roles and responsibilities of the IRP or RP. Take it. Now 19.2 says that the IRP or RP shall make the application to the AA in case of non-cooperation from CD. We have understood the provisions of custody and control also just now, where the assets and records have to be requisitioned from the CD. Taken. So under 19.2, IRP or RP can make application to the AA, and in case of non-cooperation from CD, its promoters or any other person who is required to assist or cooperate with the IRP or RP. Regulation 20 says that he shall protect and preserve the value of property of the CD and manage its operations as a going concern. He can appoint accountants, legal or other professionals as may be considered necessary. Regulation 22, 20, sub rule 2, sub regulation 2, regulation B, it says he can enter into contracts on behalf of the CD or amend contracts entered into before the commencement of CIRP. Because sometimes the management, in order to favor somebody, enters into contracts with persons, with third parties, which are prejudicial to the company. So he can amend those contracts. He can even terminate those contracts. Okay. Another power with the IRP or RP is that he can raise interim finance within the limits set by COC, and once those limits are crossed, then with the approval of the COC, he can raise interim finance. He can issue instructions to the personnel of the CD for keeping it as a going concern. Suppose any information is asked for by the members of the COC. So the IRP or RP shall make financial information available to the members of the COC within 7 days of such requisition. Okay. Regulation 22. Confirmation of IRP as RP or replacement with another IP as RP. File application with the AA for replacement of IRP with the name of the proposed RP. So we will provide all information, documents and records pertaining to the CD to RP. Filing of withdrawal application before the adjudicating authority. In case this is governed by section 12A and regulation 30A. Suppose an application has been, insolvency petition has been admitted, and then the creditors want to withdraw it. So an application has to be made by the applicant for filing of withdrawal, and there are certain provisions which say that whatever have been the cost incurred till date, so a bank guarantee for that estimated amount has to be attached with the application, and it can be made at 3 stages, this withdrawal application. Number 1, when the COC has not yet been constituted. Suppose a financial creditor made an application, it was admitted, but the debtor made the payment, the CD made the payment, and now the financial creditor is not interested in pursuing the application. So he will request the IRP or RP, so he will make an application to the adjudicating authority for withdrawal. Second is when COC has been constituted. In case COC has been constituted, then the COC will take a call, and COC has to agree with 90% majority for agreeing to the withdrawal. Third stage is when the request for expression of interest has been made. That means Form G has been issued. So in that case, the COC has to provide reasons also why they want to withdraw the application. Regulation 33 talks of ratifying the expenses of the insolvency resolution process. Then there is a mandate of preservation of records relating to CIRP of CD. Regulation 20 talks of service of notice of meeting of the COC by electronic means. Subject line should have name of the CD, date, time and venue. So IRP or RP has to conduct the CIRP process in compliance with the procedure under the code and regulations. Section 23, subsection 2, read with section 17, it says that management of affairs of the CD, and he will exercise the powers of the board of directors of the CD. Compliance of the requirements under any law. Modifying percentage of voting rights required for quorum. This can be done with 33%. Record COC meetings and prepare information of memorandum and circulate the information of memorandum to participants in electronic mode within 40 minutes of meeting. Record COC meeting and prepare minutes of meeting and circulate minutes of meeting to participants in electronic mode within 48 hours of such meeting. RP should give notice of meeting to the COC, AR of COC. Now, even the facilitators, they can attend the meetings as observers. The notice of meeting shall be given to the suspended board of directors also, and operational creditor or AR of OC if the debt is minimum 10% of the total debt. Then they also shall get the notice of meeting. But only the unrelated financial creditors, they shall have the right to vote. The IRP or RP shall convene, attend and conduct the meetings of COC, including participation through video conferencing and voting through electronic means. He will convene meetings of the COC wherever required or on request made by members of the COC representing 33% of voting rights. The members of the COC may reduce the notice period also for holding COC meeting. He has to preserve and protect the assets of the CD, including continued business operations. He has to take control and custody. He has to represent and act on behalf of the CD with third parties. Suppose some arbitration proceeding is going on. So in that case, the IRP or RP shall represent the CD. And he has to exercise the rights for the benefit of the CD in judicial, quasi-judicial and arbitration proceedings. Regarding approval to raise interim finance, COC may agree that okay, up to a certain limit, the IRP or RP can himself raise the interim finance, and beyond a stipulated limit, then he can take prior approval of COC, which is given in section 28. He can appoint accountants, legal or other professionals. He has to maintain the updated list of claims, including verification and determination. Now, Regulation 27 says that the IRP or RP shall appoint registered valuers within 7 days of his appointment, but not later than 47th day from the insolvency commencement date. An RP may ask for third valuer if he thinks two estimates of the value are significantly different. Then average of two closest estimates is to be considered by the RP. Okay. Regarding assignment of debt, whether it is allowed, the answer is yes. So, in case of transfer of debt by a creditor to another person, RP to notify each participant and the adjudicating authority and the change in COC due to this within 2 days. Okay. Sale of assets outside the ordinary course of CD, RP can do with 66% voting. Withdrawal of application, Regulation 30A. So withdrawal of application is in 3 stages. Before the COC is constituted, then the IRP or RP can submit the application to AA within 3 days of the receipt from the applicant in form FA. Okay. And applicant needs to submit bank guarantee for the estimated amount of expenses. And once the application is approved by the AA, then applicant needs to submit cash in the CD's bank account within 3 days of approval from the AA. Otherwise, bank guarantee will be invoked. Regarding liquidation value, RP shall share it with the COC and suspended board only after receiving from the RP and after taking confidentiality undertaking, and RP to share valuation report in electronic form. Regarding preferential transactions, RP to form an opinion on or before 75th day from the insolvency commencement date, and he has to make determination on or before 115th day. Okay. Prepare and circulate of information memorandum to COC. So this has to be done on or before the 95th day. Just a minute. Let me check this point. Regulation number 36. Because there have been changes in this from time to time. So now it is on or before the 95th day. Okay. Regarding providing information having a bearing on the resolution plan upon request from a member of the COC. So all these are the duties and responsibilities of IRP or RP. So he has to obtain confidentiality undertaking from the prospective resolution applicants and members of the COC with whom he is sharing this information memorandum. Publication of invitation for expression of interest, it should be done not later than 60th day from the insolvency commencement date from prospective resolution applicants in Form G. EOI should specify the criteria for prospective resolution applicants as approved by the COC. Because as per section 25(2)(h), the committee of creditors specifies the criteria for prospective resolution applicants. And this has to be communicated to the prospective resolution applicants. Ineligibility criteria under 29A and information about the CD. All these things has to be given in the expression of interest. Due diligence of expression of interest received to assess compliance with criteria specified, including seeking clarification, additional information. He will issue provisional list of eligible prospective resolution applicants within 10 days of the last date of submission of expression of interest. He will issue the final list of eligible prospective resolution applicants within 10 days of the objection received. Then issue of information memorandum, evaluation matrix, and request for resolution plans, including performance security requirements. Then details or parameters of evaluation matrix and request for resolution plans. He can extend the timelines for submission of resolution plan. There can be a case of reissue of request for resolution plan also. Then, as per regulation number 37, 38 and 39, the RP shall present all resolution plans which fulfill the required criteria at the meetings of the COC. RP shall file application for avoidance of transactions on 30th day. Section 27 talks of replacement of the RP.
रेजोल्यूशन प्लान के बारे में थोड़ा बताओ ना सर.
अभी बताते हैं, अभी करते हैं. रेजोल्यूशन प्लान के बारे में पूरा अलग से डिस्कस करेंगे. हाँ. Then creation of security interest over assets of the CD, that can be done with the approval of the COC. So section 28 talks of certain approvals by the COC, prior approval of the COC. Creation of security interest over assets of the CD, changing the capital structure, recording any change in the ownership of interest, then payment.
Excuse me, sir.
Yes, please.
What kind of change in capital structure will be made, sir?
Change in the capital structure, suppose there is some payment. So even payment is included. Suppose some repayment of capital is there.
Okay.
So that is also change in the capital structure.
Okay.
If we read section 28, so section 28 says regarding the change in capital structure, including by way of issuance of additional securities, creating a new class of securities, or buying back or redemption of issued securities in case the corporate debtor is a company. So they have given in 28(1)(c) the examples of change in capital structure also. So it could be additional securities, creating a new class of securities, or buying back or redemption of issued securities in case the corporate debtor is a company.
Right, sir.
Then record any change in the ownership interest of the CD. So if there is any change in the ownership interest of the CD, suppose some new person is buying the shares, because sale and purchase of shares is not prohibited even during CIRP period. Suppose it is a listed company, then somebody may buy and somebody may sell. But any record of change in the ownership interest has to be done only with the approval of the COC with 66% majority. Then COC may specify certain payments limits also from bank accounts of the CD, that okay, up to this limit, debits are allowed as per the request of the RP, but beyond those, COC approval is needed. Okay. Then for undertaking any related party transactions also, COC approval is required. If there is any amendment to the constitutional documents of the CD, for that also, approval of the COC is required. For delegation of authority to any other person, for disposal of or permit the disposal of shares of any shareholder of the CD or their nominee to third parties. If there is any change in the management of the CD or its subsidiary, if there is a transfer of rights or financial debts or operational debts under material contracts, otherwise in the ordinary course of business, if there is a change in the appointment or terms of contract of such personnel as may be specified by the COC. For making any changes in the appointment or terms of contract of statutory auditors or internal auditors of the CD, appointment of registered valuers has to be done maximum by 47th day. Then every participant of the CD and A has to be notified of any change in the COC consequent to assignment or transfer of debt by a creditor within 2 days of such change. If there is a sale of assets outside the ordinary course of business, and there is a capping also that it cannot exceed book value of not more than 10% of the admitted debts. Then section 19, read with regulation 30, talks of applying to the AA seeking assistance of local district administration. There could be issues in taking control and custody, in accessing information, somebody's non-cooperation. So for all this, section 19.2. 12A we have already seen, filing of withdrawal application. Then regulation 34, it talks of fixing of the expenses of the RP, disclosure of insolvency resolution process cost, and determination of the transactions of PUFE nature. Then section 30, it talks of submission of the compliant resolution plans to the COC. And mandatory contents include details of the previous non-implementation, if any, of resolution plans by the resolution applicant, along with details of irregular transactions, that means PUFE transactions, and order of A, if any, on these transactions. Okay. Evaluation of these resolution plans will be strictly as per the evaluation matrix, and approval of resolution plan with modifications, if any, with reasons recorded for approval or rejection. Submission of resolution plan approved by the COC to at least 15 days before the maximum period of insolvency. That means by 165th day, along with compliance certificate in Form H and the evidence of receipt of performance security. So till the time the resolution plan is approved, the RP shall continue to manage the operations of the CD until the order is passed by the adjudicating authority under section 31. Communicating order of the AA, sending copy of the order on resolution plan to participants and the RS. Preservation of records relating to CIRP. Regulation 39B talks of meeting the liquidation cost, where a resolution plan is rejected. COC to make best estimate. Just a minute. ये ऐड कर लीजिए किसी को कौन आ रहा है इसमें. Meeting liquidation cost, where the resolution plan is rejected. So COC shall make best estimate of the liquidation cost, and if estimated value of the liquid assets is less than the cost of liquidation, then COC to provide a plan for contribution of that amount. So who will contribute? The financial creditors being financial institutions. They will contribute in the proportion of their debt. Regulation 39C talks of assessment of sale as a going concern in liquidation, and committee to recommend to liquidator to first explore this option, and COC to identify and group assets and liabilities that can be sold as a going concern. Regulation 39D says that the committee may, in consultation with the RP, fix the fees payable to the liquidator. So there are three types of fees. Number one, period used for compromise arrangement. Second is period used for sale of the CD or business of the CD as a going concern. And third is balance period of liquidation. Regulation 40 talks of application to the AA for extension of the CIRP period, and committee may instruct RP to do so with 66% majority. If there is a pecuniary or personal relationship with any of the stakeholders or association with CD, then the RP has to disclose this relationship. So these are some of the roles and responsibilities of the
Sir, the last one, is it FC or CD, sir?
With the CD and FC both.
Okay,
So RP may be related with, say, any of the stakeholders.
Right, sir. With stakeholders, right.
Right. So these are some of the duties of the RP and COC. Now let us, as requested by Vijay Kumar Bamne ji, let us see some of the provisions regarding this resolution plan. Just a minute. Just a minute. So I think for that we can go to regulation number 36. Directly we can go to regulation number 36 for that. 36. Right. Resolution plan. Provisions regarding resolution plan, they are given in chapter 10. So first of all, fair value and liquidation value. I hope my screen is visible. So first of all, fair value and liquidation value. So who will ascertain the fair value or liquidation value? Two registered valuers. So they will give the fair value and liquidation value, and average shall be taken. Now, suppose two estimates are significantly different, or COC recommends that okay, you appoint third valuer also. So then third registered valuer can also be appointed. Okay. And what is the meaning of significantly different? Significantly different means a difference of 25% in liquidation value. An average of the two closest estimates shall be considered the fair value of the liquidation value of the case may be. Now, first of all, understand what is the purpose of ascertaining this fair value or liquidation value. What is the purpose? The purpose is now because we are inviting resolution plans. So any resolution plan because one of the objectives of IBC is maximization of the interest of all the stakeholders. So if the resolution applicant is offering something less than the fair value, then such plan need not be entertained. Similarly, there is stipulation regarding liquidation value, payment of liquidation value to operational creditors, because normally operational creditors will not be entitled to vote in the meetings of COC. Only unrelated financial creditors have the right to vote in the meetings of the COC. So now what is the safeguard available to the operational creditors? So the safeguard available to the operational creditors is that they should get at least the liquidation value. Now another question, whether this liquidation value or fair value is disclosed to the resolution applicants? The answer is no. So this value is not available with the resolution applicant, but he has to ensure that he offers something which in no case should be less than the fair value or liquidation value. Otherwise, his plan will not be entertained. Okay? But RP is having this value. So what RP can do is, RP can assess whether the resolution plan is offering something more than the fair value or liquidation value. This is the purpose. Okay. Now, second question, whether members of the COC, they are entitled to look at the fair value or liquidation value? The answer is yes. Okay. So after the receipt of resolution plans, in accordance with the code and regulations, the resolution professional shall provide the fair value, liquidation value and valuation reports to every member of the COC in electronic form on receiving an undertaking from the members to the effect that such member shall maintain confidentiality of the fair value, the liquidation value and valuation reports, and shall not use the information to cause an undue gain or undue loss to itself or any other person. Okay? The resolution professional and registered valuers shall maintain confidentiality. Now preferential and other transactions, there is a timeline 75, 115 and 130 days. Information memorandum. So what is this information memorandum? Information memorandum is the basic document. Basically, but before we go to this information memorandum, let us see whether the resolution applicant will come to know whether PUFE application has been filed. The answer is yes. Okay? The resolution professional shall forward a copy of the application to the prospective resolution applicant to enable him to consider the same while submitting the resolution plan within the times initially stipulated. The creditor shall provide to the RP relevant extract from the audit of the corporate data. That is okay. So the idea here is why this resolution applicant is intimated about the filing of PUFE transactions, because there might be some recovery from those PUFE transactions. And while submitting his resolution plan, he considers those things also, that what will, to whom that property will go. Suppose an application for PUFE transaction has been made to the adjudicating authority and decision may come at a later stage. So then the resolution applicant has to consider that aspect also, that is, there is some recovery, whether it will belong to the CD or to the resolution applicant, and he has to indicate this thing in his resolution plan. That is why he is intimated about these PUFE transactions. Now, information memorandum. What is the logic of this information memorandum? Because the resolution applicant must have some basic information about the company for which he is going to submit the plan. And that plan cannot be submitted on the basis of books, because books are based on historical values. But now this information memorandum, it is based on the fair value and liquidation value. So subject to sub-regulation 4, it is based on the claims. There might be certain amounts which may be, say, assets or liabilities appearing in the books, but they may not exist. Some say fictitious purchases or sales may be there, and accordingly creditors or debtors may be not correct. So based on the claims submitted, based on the information, the RP shall prepare an information memorandum. So RP shall submit the information memorandum in electronic form to each member of the committee on or before the 95th day from the insolvency commencement date. Take it. So what this information document will this information memorandum shall contain? The information memorandum shall highlight the key selling propositions and contain all relevant information which serves as a comprehensive document conveying significant information about the corporate data, including its operations, financial statements, to the prospective resolution applicant, and shall contain the following details of the corporate data: assets and liabilities, including description, latest latest annual financial statements, audited financial statements, list of creditors, particulars of debt, details of guarantees, name and addresses of the members or partners holding. So all this information is given in the information memorandum. Okay? Details of all material litigation and ongoing investigation. So this is one of the important documents which is given to the prospective resolution applicant. Okay? Then fair value. Fair value is also included in the information memorandum. This is the change. Provided that the committee may decide not to disclose the fair value if, for reasons to be recorded in writing, it considers such non-disclosure to be beneficial for the resolution process. So COC has to take the call whether this fair value has to be disclosed in the information memorandum or not. But liquidation value is not disclosed. Take it. A member of the committee may request the RP for further information, and RP shall provide such information within reasonable time. The resolution professional shall share the information memorandum after receiving an undertaking from a member of the committee. Okay. Now, invitation for expression of interest, Form G. So Form G is the first thing to be issued. Form G is issued in the public domain. The resolution professional shall publish brief particulars. Let us have a look at Form G also. So this is Form G. So Form G contains basic information about the company, and it indicates where the detailed information is available. So it says further details including last available financial statements with schedules of 2 years, list of creditors are available at URL. So they may indicate the name of the website where further information will be available. So this is the first thing which is available to the resolution applicant. Form G. So Form G will take him to a URL where detailed invitation, details for expression of interest are available. Take it. There is a timeline also. So it has to be issued not later than 60th day from the insolvency commencement. Form G. Take it. The resolution professional shall publish Form G in one English and one regional language newspaper on the website if any of the CD website designated by the board. Okay. So Form G shall state where the detailed invitation for expression of interest can be downloaded or obtained, and provide the last date for submission of expression of interest, which shall not be less than 15 days from the date of issue of detailed invitation. Okay. Now detailed invitation. It shall specify the criteria, because in Form G is to be published in newspapers. So very minimum information is available. But it is the first interaction with the resolution applicant. So resolution applicant will come to know that okay, this company is seeking resolution plans when he sees the Form G in the newspaper or on the website of the board. Okay. Then it will take him to detailed invitation. So detailed invitation shall specify the criteria from prospective resolution applicants as approved by the committee, state the ineligibility norms. Now here one question, whether this detailed invitation shall entitle him to get a copy of the information memorandum? The answer is no. At this stage, information memorandum shall not be given to the prospective resolution applicant, because first we are checking their eligibility. Okay? So Form G will take them to the detailed invitation for expression of interest. So what it takes, what it contains: criteria for prospective resolution applicants as approved by the committee, and eligibility norms, such basic information about the corporate data as may be required by a prospective resolution applicant for expression of interest. So this is something similar to tender. Suppose invitation for tender is there. You might have seen in newspapers invitation for tenders, and they say that okay, you obtain the details from our website or from this page. You know? So detailed guidelines are available. So this is something similar. So this process is something similar to the process of tendering. First of all, he will come to know about this thing from the newspaper, and then he will go at that website or that address, so where details are available. Okay? So these details, through these details, we can select the prospective resolution applicants. Okay? Provide details of the corporate debtors registration status as MSME. Provided that where the corporate debtor has any real estate project, the committee for an association or group of allottees in such real estate project representing not less than 10% or 100 creditors out of the total number of creditors in a class, whichever is lower, may relax the following. Because in case of real estate projects, sometimes the home buyers, they also become the resolution applicant. So in that case, some conditions may be relaxed. So what could be those relaxations? The relaxations could be regarding the eligibility criteria. Okay? Eligibility criteria for submission of expression of interest, and then conditions regarding the refundable deposit. So what are the conditions for that? The conditions are where a corporate debtor has any real estate project. So committee may, for an association or group of allottees, suppose an association is desirous of putting a resolution plan. So in that situation, where not less than 10% or 100 creditors out of the total number of creditors. So condition may be relaxed. Relaxation could be regarding the eligibility criteria. It could be regarding conditions regarding refundable deposit. Whether this invitation for expression of interest can be modified? Yes, it can be modified, not more than once. Okay. Then a prospective resolution applicant who meets the requirement of the invitation for expression of interest may submit expression of interest within the time specified in the invitation under clause B of sub-regulation 3. Okay. So what is clause B of sub-regulation 3? The clause B of sub-regulation 3 says not less than 15 days period. Okay. From the date of issue of detailed invitation. So if an expression of interest is received late, so it shall be rejected. So it is to be accompanied with certain documents, undertaking, relevant records, undertaking that is eligible. Taken. So basically, now they are assessing his eligibility. The resolution professional shall conduct due diligence based on the material. Taken. So we will see that the conditions which are given in section 25(2)(h).
सर आपका स्क्रीन तो नहीं दिखा रहे सर.
स्क्रीन नहीं दिखा रहा है? ऐसा कैसे?
पता नहीं सर.
अरे मैं आप मुझे बता देते, मैं शेयर कर देता.
यस सर.
कोई बात नहीं. ये है. ओके, आप मुझे बता दिया करो, कभी कभी हो जाता है सर. आई होप नाउ इट इज विजिबल. इज इट विजिबल नाउ?
यस सर. थैंक यू सर.
Yes. Sorry. So expression of interest shall be unconditional and shall be accompanied by an undertaking. Basically, here they are assessing the eligibility of the resolution applicant. Now, next stage is request for resolution plans. This is the next stage. Now, once the RP has assessed that the resolution applicant is eligible, so there is no ineligibility under 29A, and he meets the conditions which were put forth by the COC in 25(2)(h). So now he shall within 5 days of the date of issue of the final list. Okay. Yes. So before that we can go to this 36A 10. The resolution professional shall issue a provisional list of eligible prospective resolution applicant within 10 days of the last date for submission of expression of interest. So first of all, he will prepare a provisional list, and there could be objections also. So any objection could be made within 5 days from the date of issue of the provisional list. Okay. And on consideration of the objections, the RP shall issue the final list within 10 days of the last date for receipt of objections. So what is the first stage in the resolution plan? Form G, invitation of Form G. Form G will take him to detailed invitation for expression of interest. That has to be submitted not less than 15 days from the date of issue of the detailed invitation. And then the RP will assess his eligibility. He will prepare a provisional list within 10 days, and within 5 days objections can be made. And then within 10 days of the last date for receipt of objections, he will make a final list of the prospective resolution applicants. Now, to those who have entered the final list, he will issue the request for resolution plan. The resolution professional shall within 5 days of the date of issue of the final list issue the information memorandum. So this information memorandum, evaluation matrix, and a request of a resolution plan has to be made only to those who are selected by the RP based on their submission of detailed invitation for expression of interest. ठीक है. RFRP. So resolution professional shall within 5 days of the date of issue of the final list issue the information memorandum, evaluation matrix, and a request for resolution plan to every resolution applicant in the final list, provided that where such documents are available, the same may also be provided to every prospective resolution applicant in the provisional list. Okay. The request for resolution plan shall detail each step in the process and the manner and purpose of interaction between the resolution professional and the prospective resolution applicant along with corresponding timelines. So here, what they will do, the request for resolution plan shall detail each step in the process and the manner and purpose of interaction between the resolution professional. Now, because various meetings shall take place, so it will detail each step in the process. like okay, COC meetings shall take place, which will deliberate on the resolution plans. There will be discussion and all those voting, etc. So RFRP shall detail each step in the process and the manner and purpose of interaction between the resolution professional and the prospective resolution applicant along with corresponding timelines. The request for resolution plans shall allow prospective resolution applicants a minimum of 30 days to submit the resolution plans. तो यहाँ पर इनको 30 days का टाइम दिया गया. मैं आपको एक और चीज दिखाता हूं रिगार्डिंग दिस रिक्वेस्ट फॉर रेजोल्यूशन प्लान. Just let me see. I think it is available.